rise again in support of the Policing Storage of Youth Identifying Particulars Amendment Bill. Mr Speaker, I was interested in the comments of the previous speaker. I suspect that the heartfelt appeal that the Speaker has made on behalf of the Maori Party for Maori youth is misguided in this debate. This debate is not about changing or introducing something that isn't there already. It's about correcting a mistake that was made inadvertently by the Parliament. And I suspect that the debate that the Speaker would like to have is whether or not these records should be kept or not. That will be a debate for another time and another piece of legislation. I was also interested to hear the comments from the Green member who suggested that they hadn't been taken into the confidence of the government over this bill. Confidence is a thing that goes both ways. If they had been and the information contained within the proposals had been let out into the public arena, then of course that would have created some problems for the police and potential costs to the justice system. So the member should go back perhaps and talk to the co-leadership and his own caucus and ask why it is that they feel they may not have been taken into confidence, because as you've just heard from the Maori Party, they were, and they maintained that confidence. So that's the challenge I throw out there, and I look forward to response to that. Mr Speaker, I would also like to bring to the attention of the House that if these amendments were not able to be made in the way that they are, then there is a high probability that there would have been some potential further litigation or appeal against some of the information that's been kept, and that would have only wasted the time of the justice and police departments and achieved nothing. And finally, I will say, Mr Speaker, I'm pleased that the member, Mr Hipkiss, raised the fact that I'm now no longer in the age group that's eligible to be affected by this bill, but I would suggest back to the member that he should pay very close attention to the detail of this bill, because his own records may indeed still be captured under the provisions here being discussed, and I suspect that he will pay attention to the detail. Thank you, Mr Speaker.
Call Carol Beaumont.
Very much, Mr Speaker. I rise to speak in support of the Policing Storage of Youth Identifying Particulars Amendment Bill. And I've been listening to this debate very carefully, and I find it quite fascinating. I find it fascinating how this is being construed and the sorts of arguments that are being presented. Look, as I see it, and I'm not going to look at this from a historical point of view or even a technical point of view. I wasn't in Parliament when this bill was passed, and I certainly don't have the technical expertise of colleagues like the Honourable Leanne Dalzell. But it seems if we just take a very simple common sense approach, and I know that word gets overused and I say it with some nervousness, what we're talking about essentially here is a mistake that was made in a piece of legislation which has some significant consequences. I would have thought in that case, and I think, the Honourable Leanne Dalzell has absolutely referred back to the Hansard at the time and been very clear in that and looking at that what the intention of Parliament was, and that is always important when we look at our legislation. What was the intention of Parliament at the time? And the intention of Parliament at the time was clearly not to make the change that has been inadvertently made in this legislation. Now, it seems to me that the average person living in this country would think, given that circumstance, that it is the responsibility of Parliament to fix that mistake, not to create a long and unnecessary debate about one very specific matter, but to actually fix the mistake that everybody agrees was made. I haven't yet heard a speaker stand up and say, no, that was not the intention of Parliament, and we strongly did this and that and the other thing at the time. Clearly, the intention of Parliament was not to end up with the outcome that we have currently got. And so what is being sought here is to amend the Policing Act to restore the legal position in relation to the storage of youth identifying particulars, and that's fingerprints and photographs, for example. Now, the Honourable Annette King took us through the process that she led as Minister around amending the Policing Act. And I also would say that everybody in this House understands that that Annette King has a reputation for being a minister in her time as a minister who is very thorough, who actually was, and as she's often been described, a safe pair of hands. She undertook a long consultative process of 2 years in looking at an act that was 50 years old. She has recognised in this House, as we all have, that there was a mistake made during that process. But given the long process and given the complexity of some of the things that were being changed in that legislation, it is hardly surprising. This does happen from time to time, and Parliament should be duty-bound to fix that. So now we have the situation that that there is loopholes that could be created, and that there are young people who are not going to be picked up for committing subsequent crimes because their identifying particulars cannot be stored because of a technicality. Now, Charles Chauvel, and this has been quoted by others, has talked about what we need to do when there are legislative mistakes, and we try not to make them. I think that's the first thing. That he's quoted in Hansard as talking about trying to identify how and why mistakes are made so we don't repeat that problem. Because as a Parliament, we want to pass good law. I think everybody in this place would agree with that. We want to pass good law that will stand up and reflects the policy intention, reflects the consideration that was undertaken by Select Committee where the public have their say, and reflects what you are trying to achieve, and not to create unintended consequences as has happened here. So I think that I put a lot of weight on the reference to what was in Hansard around this particular provision. I think that makes it very, very clear that there was no intention for this to happen. So the storage of the youth identifying particulars is vital for the detection of youth offenders who go on to re-offend, as I've said. And it's important we have the correct mechanisms to prevent youth offenders from progressing to adult criminals. I think the sooner that we pick up people who are offending, the more that can be done to try and stop them going down a certain path, and especially with young people. We want to be able to intervene at the earliest available opportunity to identify what the underlying problems are, to try and ensure that that they do go down a different track. And if that is delayed because we do not have, the police do not have the ability to identify somebody in a repeat situation, then the consequences will come to the fore just later. They will come to the fore later. I think we all agree that early intervention around youth offenders is important. So rectifying the mistake that was made is vital to solving crimes and is vital to providing early assistance and intervention for our young people. And later we'll be talking about the parts of the bill, but it's a pretty simple bill. The first part really just says that it's retrospective, and the second part looks at repealing Section 34 and inserting a new Section 34 and 34A to clarify the instances under which the IP, the identifying particulars of young people will be destroyed. So it looks at that situation. I just think there are two factors here in terms of general rules, however, and I understand why the Greens and Māori Party are raising concerns. And I think it is important that we are scrupulous about these things, particularly around retrospective legislation. I think that we all do want to be scrupulous around those sorts of situations because that is important, and we do want to be scrupulous about process. And we here in the Labour team have often raised concerns about process under this current national government and the abuse of urgency and the lack of scrutiny and the lack of evidence base in legislation. But we do not believe in this particular circumstance that this is what the problem is. We are talking about dealing with something that everybody agrees is a mistake. Now, the broader issues that have been raised in this debate are very, very important ones. The causes of crime. We all want, I think, to get to the bottom of the causes of crime. I think one of the differences is that on this side of the House, we understand that increasing inequality and poverty are part of the problem, and that this is something that is going on in this country as we speak. More and more people are struggling to make ends meet. The gap between rich and poor is growing. Our young people, our children are being disadvantaged. Too many of them are living in poverty. Too many of them are unemployed. Too many of them are not in education, jobs or training. These are serious issues that we keep raising, and I'm afraid to say the government has really, really failed in regard to our young people. These are important questions to deal with when we're talking about the causes of crime. But I do think we need to ensure that the police have the tools they need to identify if people are starting down a criminal track and to intervene so we can try and do something about that earlier. I do also think it would be very good for us to have a much more substantive debate about the causes of crime and indeed hear the voices of young people. I had the privilege recently with my colleague Charles Chevelle in visiting Arahata Prison and speaking to a number of the women that were there undertaking the drug and alcohol problem, and I think they were very pleased to have two MPs asking their view on what it was that led them to be there and what it was that would make a difference when they are released from prison to them reoffending. It was a very, very interesting conversation and a lot of good insights came from that. People want to have the skills to get a job. People want a chance and people want to deal with things like addiction. So these are important things. But hearing that directly from the women that are in Arahata was very, very powerful for me. So, as I say, I do understand why there's a debate here, but I do think that if we want to talk about issues about the causes of crime, if we want to look at particular disadvantage of Māori, and I absolutely accept that Māori are absolutely overrepresented. I mean,
I'm sorry to interrupt the honourable member. Her time has expired. Dr. Cam Calder.
Mr. Speaker, thank you for the opportunity.